Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy, popularly known as AAA. This is pertaining to landmark judgment, that is serial number 84, ALIGARH Muslim University versus Naresh Agarwal. So this is the case which we are going to deal with in detail. But it is our regular practice that we recite the preamble of the Constitution. We strongly believe that preamble our goal and preamble our soul, because whatever the objectives, whatever our founding fathers dreamt about our country, it is being reflected in the preamble. So therefore it is our bounden duty to remember, to retain and apply in real terms. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Now, in this lecture number 54, we are going to discuss with what are the reasons for the decision and what is the conclusion. Ultimately, though it was running to 501 pages, Lordships have summarized nearly 8 points for the benefit of all of us. So that also will be discussed. Now, coming to the reasons, one by one, let us discuss. Let us first address this issue, the preliminary objections by the Union of India. According to them, what is their problem is, the 2 judges bench should not have referred the matter to the 7 judges bench. To discuss this issue, the Lordships have referred to a very landmark judgment, dear friends, that I will refer. The name of the case is Central Board. This is para 37 of the judgment. Central Board of Dawoodi Bohra Community. I repeat, Central Board of Dawoodi, DAWOODI, Dawoodi Bohra Community. This is very important judgment because the law laid down by the Supreme Court in this case is, when 2 judges can refer a matter to the larger bench and how it can be done. And they have discussed about 2 doctrines, dear friends. Doctrine of judicial discipline. What is doctrine of judicial discipline? The larger bench judgment must be followed by the smaller bench. If the Honorable Supreme Court delivers a judgment, that has a binding effect on the High Courts as well as on the District Courts. So, High Court is bound to follow Supreme Court judgment. Division bench of the Supreme Court is bound to follow the Constitution bench judgment. That is what the judicial discipline is. Doctrine of precedent. What was held earlier, that has to be followed. But if you are unable to digest, if you are unable to accept with the views taken by the constitution bench, then how the matter has to be done? That is what discussed in Community Board of Dawoodi Bora community. So I will read for you, dear friends. A constitution bench discussed the legal precepts which apply to orders of reference and reiterated the position of law as below. A. Decision of this court rendered by a bench of larger strength are binding on benches of less or equal strength. For example, this is very important. When 5 judges have decided the case, so 5 judges judgment is binding on 2 judges also, as well as binding on the equal strength. If there are 5 judges sitting, even that they are also bound by this decision. So decision of this court rendered by a bench of larger strength or binding on benches of a less or equal strength. B. The principle is, if a bench of a lower strength is doubtful about the correctness of a judgment delivered by a bench of larger strength, that is Anjuman-e-Rahmaniya, 2 judges bench, they have doubted the correctness of the 5 judges bench rendered in Aziz Basha case. If a bench of a lower strength is doubtful about the correctness of a judgment delivered by a bench of larger strength, it cannot disagree. 2 judges cannot disagree or dissent from the view taken by the larger bench. So they can never disagree also, they cannot give a dissenting opinion also, but they are unable to follow also. So what is the, in this situation, what the 2 judges bench can do? In case of doubt, it can invite the attention of the Chief Justice of India to its opinion and request the Chief Justice to list the matter before a bench, the strength of which is greater than that which delivered the judgment which has been doubted. So 2 judges can make a request to the Chief Justice of India. Why not to the senior most judges? Why only to the Chief Justice of India? Reason is, Chief Justice is the master of the roster. What is master of the roster? It is his prerogative to determine which case has to be dealt by which bench and what is the quorum of that bench. Who will sit in this quorum? Which matter they will decide? Everything is dealt only by the Chief Justice of India. So therefore, letter addressed to the Chief Justice. C. The correctness of the view taken by any bench. See, this is third position, dear friends. The correctness of the view taken by any bench can only be doubted by a bench of equal strength. The matter will then be placed for hearing before a bench of greater strength. This is yet another occasion. If it is 5 judges bench questioning the correctness of the 5 judges, then the matter can be placed before the larger bench, that is 7 judges. There are 2 exceptions to it. There are 2 exceptions. Firstly, discretion of the Chief Justice is not bound by the rules. Dear friends, we think that this law is going to bind on the Chief Justice of India. What they are saying is, there are 2 exceptions. Firstly, the discretion of the Chief Justice is not bound by the rules. As the master of the roster, the Chief Justice may list any case before any bench of any strength. See their discretionary power. The Chief Justice of India may list any case before any bench of any strength. Number 2 exception is, despite the rules discussed above, if a particular case has come up for hearing before a bench of larger strength, and that bench is of the opinion that the judgment of the bench of lower strength requires reconsideration or correction or is otherwise doubtful of its correctness, it may dispense with the need for a reference in the terms described above or an order of the Chief Justice and hear the matter for reasons given by it. The second aspect is what they are saying is when 7 judges bench is questioning the correctness of a judgment rendered by 2 judges or 3 judges, they need not refer the matter. This larger bench, 7 judges bench, need not refer the matter to the Chief Justice of India. On the contrary, they themselves can decide because they have a larger bench. 7 judges always can question the correctness of the 2 judges or 3 judges bench. So they can do so. There is no further reference to the Chief Justice of India. So this is very important. 3 aspects we have learnt from this. One is doctrine of judicial discipline, doctrine of precedent, and master of the roster, and how under various occasions, under 3 occasions, how the matter is referred to the larger bench and what are the exceptions. The most important exception is Chief Justice is not bound by any rules. He can refer any matter to any court to deal with any case. So they are not bound by any rules, dear friends. So accordingly, what they have said is, in this case, the referral by Anjuman-e-Rahmaniya to the larger bench fall under the category of the principle B, the second point, because here 2 judges doubted the correctness of the judgment rendered in Aziz Basha 5 judges. So therefore they have referred the matter to the Chief Justice of India to constitute a larger bench. So that falls well within the parameters. Therefore the referral was correct. There was nothing wrong. So objection raised by the Union of India was rejected. So this was the first aspect with respect to the referral is concerned. Now coming to the second aspect, the scope of Article 30. This is very important, dear friends. See, the interpretation Article 30 for everyone we can read, but how it is being interpreted, how each word was interpreted by our lordships, that is very important. What does it say, Article 30? More particularly Article 30 Clause 1, all minorities, whether based on religion or linguistic, shall have right to establish and administer the education institution of their choice. So they have the right. So this is what Article 30 Clause 1 says. Article 30 Clause 1 are viewed under 2 categories, dear friends. Firstly, it is non-discrimination clause. Why it is considered as non-discrimination clause? What is non-discrimination? That means there is no discrimination. That means there is a equality. What is the equality? The other institutions, other education institutions are there, but these religiously minority or linguistic minority cannot be discriminated between the other institutions. Therefore, it gives certain protection to those minority institutions. Therefore, it is a non-discrimination clause. And what is the special protection given? This is the second view is Article 30 Clause 1 is viewed as a special right. What is the special right? The special right is given to the minority institution to have a specific benefit for their students belonging to the same community. For what purpose? To save their culture, to save their language. So the fabric of the culture, fabric of the language must be protected. So beautifully lordships have given an example also. If a Tamil speaking person is starting a school for the benefit of Tamil students, right? For the benefit of the Tamil students, it can be done so because he wants to promote the language. He wants the younger generation who is brought up in Delhi may not know Tamil properly, therefore they should know Tamil. Therefore, institution was started. So this is correct. A minority institution under Article 30 Clause 1 can be viewed under two ways. One is non-discrimination clause. Another one is special right provided to the minority institution to save their religion and to save their language. Now the second aspect what the honorable judges have held is, now Article 30 Clause 1, that is a part of the Constitution 1950. So whether this 1950 Article 30 Clause 1 can be extended retrospectively to the institution which was created in the year 1920. That was the question considered by the Honorable Supreme Court. Because the Constitution itself comes into force in the year 1950. How do you extend the benefit of minority institution, a protection under Article 30 Clause 1, retrospectively to the college which was established in the year 1920? That was the issue. But honorable judges, out of their wisdom, rich experience, they have held, when they started in the year 1920, when the university was incorporated, they never thought that they will get a minority status after 1950. It was never in their thought process that you will become a minority after 1950. The second aspect is, we cannot draw a line that an institution, a minority institution started after 1950 will get a protection under Article 30 Clause 1, and the minority institution which was started prior to adoption of the Constitution will not get the minority status. We cannot discriminate between prior to the Constitution, post Constitution. That is not a proper appreciation or interpretation. Therefore, the protection has to be given both to the institution which started post Constitution also, prior to the Constitution also. So that was also one of the discussions in the landmark judgment. Hope it is clear, dear friends. Now moving on to the next discussion. Now what is the test? Now we have seen Article 30 Clause 1 is provided for the ALIGARH Muslim University which was established in the year 1920. Now next aspect is, what is the test? Test to determine whether it is a minority institution or not. So now they are moving on to the interpretation of the term establishment and administration. So what is establishment? Very important aspect. The Lordships has summarized in 3 paragraphs. The test is to test whether it is established under minority is idea. Number 1. The idea, first, this idea must come from a minority, that a Muslim must think that let us start a Muslim university for the benefit of the students. So that origin, that brain must originate from the Muslim community only. That is the first test, idea. Second test is purpose. What is the purpose? The purpose for starting the Muslim university is to provide benefit to the Muslims community at large. Here you have to see very carefully, dear friends, predominantly benefiting the Muslim students. It is not exclusively for the Muslim students. An ALIGARH Muslim University can predominantly make reservations and then they can provide larger benefit to the students, Muslim community, At the same time, they may also provide seats to other students who hail from other religion also, but predominantly benefiting the Muslim community. So, purpose. Third aspect is implementation. If a Muslim thinks that let us start the university, so it has originated from the Muslim person, and the university started for the benefit of the Muslim community, purpose is also served. Now, implementation, how do you implement it? You have to construct an university. So, where do you get the land? The Muslim person or minority person must get the land, must make the arrangement for the funds, must do all the process. So, the idea will get implemented only by that minority. Then only it will qualify the test of establishment by minority. If these tests are not fulfilled, then it will not qualify the minority test. So let us read those three important paragraphs where the lordships have beautifully explained about what are the three principles, dear friends. Paragraph number 135 at page 378. I am referring to the scale. Paragraph 135 I am reading. To determine what I have said now in the words of the honorable judges. To determine who established the institution, the courts must consider the genesis of the educational institution. For this analysis, the courts must trace the origin of the idea. See, first one is idea. The court must trace the origin of the idea for the establishment of the institution. The court must identify who was the brain behind the establishment of the educational institution. Letters, how do you prove it? Letters, correspondence with other members of the community or with government, state officials, and resolutions issued could be a valid proof for establishing ideation or the impetus to found and establish. The proof of ideation must point towards one member of the minority or a group from the community. So therefore, how do you prove it? Through resolutions, through correspondence. If there is an idea, you will always address to the state government that we are going to start this. Whether through those correspondences, through letters, you can establish that idea has come from that particular community. The second indicia is the purpose. See the term purpose, please underline. First, we have pointed out idea. P, purpose. The second indicia is the purpose for which the educational institution was established. Though it is not necessary that the educational institution must have been established only for the benefit of religious or linguistic minority community, it must predominantly be for its benefit. They have bolded actually two terms, predominantly benefiting that community, but it is not established only for the benefit. So it is not necessary that education must be provided in the language spoken by the minority or on the religion of the minority. For example, the example is given. It is not necessary that an educational institution established for the Tamils in Uttar Pradesh must necessarily prescribe Tamil as the language of instruction. If a Tamilian starts the Tamil school in state of UP to preserve his language, however, the instructions may not be in Tamil, the medium may not be in Tamil. In UP must necessarily prescribe Tamil as the language of instruction. However, I repeat, for example, it is not necessary that an educational institution established for the Tamils in Uttar Pradesh must necessarily prescribe Tamil as the language of instruction. However, it must be proved that the institution was established for the benefit of Tamil speaking community. This indicia could be proved. So how do you prove that it is started only for the benefit Tamil speaking community? The evidence is this indicia could be proved by a reference to private communication or speeches about the necessity of establishing an educational institution for the community and a recognition of the educational difficulties faced by the community. Now the third test. So we have seen idea also. Second is purpose also we have seen. Now the third test is tracing the steps towards the implementation of the idea. Implementation. Mark this term, dear friends, implementation. The third test is, in short, we can say IPI, idea, purpose, implementation. The third test is tracing the steps taken towards the implementation of the idea, information on who contributed the funds for its creation, who contributed the funds for its creation, who was responsible for obtaining the land, and whether the land was donated by a member of the minority community or purchased from funds raised by the minority community for this purpose, or donated by a person from some other community specifically for the establishment of a minority educational institution, or elements that must be considered. Similar questions must be asked of its other assets. Other important questions are who took the steps necessary for establishing the institution, such as obtaining the relevant permissions, constructing the buildings, and arranging other infrastructure. It is also important to note that the state may grant some land or other monetary aid during or after the establishment of the education institution. If the land or monies were granted after the establishment, the grant would not have the effect of changing the minority character of the institution. For example, if a person says that I am going to start a minority institution and the state is providing fund, some grant, doesn't mean that it will change the character of the minority institution. Minority institutions are not barred from receiving aid, save at the cost of their minority status. If the land or monies are granted at the time of establishment, the circumstances surrounding the establishment must be considered as a whole to determine who established the institution. The presence of a grant must not be automatically interpreted as leading to the erasure of claim to minority status. Now, we have seen the establishment. The lordships have interpreted the term establishment to test whether this establishment made by the minority. We need to fulfill three conditions. One is idea must have been originated by the minority. Purpose is to predominantly benefit that particular minority, and the implementation must also done by that minority. If the minority institution receives any aid or fund from the state government, just by getting those funds, it will not change the minority character. So this is what about the establishment is concerned. Now, next stage is administration. Because in Article 30 Clause 1 it says, all minorities, whether based on religion or linguistic, shall have their right to establish the educational institution of their choice, establish and administer. So we have to understand what is the meaning of administration. The next question is administrative structure. Whether this administrative structure has to be done only by that particular minority clause. For example, in this case, it is a Muslim university. Yes, whether minority, that particular Muslim alone has to be there in the administration, or any religious person can be there for the administration? The answer is any person can be an administrator there. Why? The reason is the particular community might feel that he is that well deserving person, very efficient person. We can have that person as an administrator. Therefore, to bring secularism within the institution, there is nothing wrong, provided that it does not change the character of the minority. So let us read that, dear friends, how it has been discussed. And they beautifully said, administration comes only as a consequence of the establishment. Only when an institution is established, then only their administration takes birth. But you cannot test that whether it is a minority or not by making administration as a precondition. So you have to see only the establishment and not the administration. So in my humble opinion, it is not a twin test, establishment and administration. It is only one test, establishment. So let us see from the words of the honorable judges, para 138. The next question is whether the administrative structure of the educational institution is an indicia. Indicia means indication, sign, representation. Is an indicia for the establishment of a minority educational institution. We have already held above that an educational institution is a minority educational institution if it is established by a religious or linguistic minority. We have clarified, see, this is very important, dear friends. We have clarified that it is not necessary, underline the term not necessary. We have clarified that it is not necessary to prove that administration vests with the minority to prove that it is a minority educational institution, because the very purpose of Article 30 Clause 1 is to grant special rights on the administration as a consequence of establishment. To do otherwise would amount to converting the consequence to a precondition. The right to administer is guaranteed to minority educational institutions to enable them. See, what is the benefit that we get when we run a minority institution? The benefit is this: the right to administer is guaranteed to a minority educational institutions to enable them to possess sufficient autonomy to model the educational institution according to the education values that the community wishes to emphasize. It is not necessary that the purpose can only be implemented if persons belonging to the community helm the administrative affairs. This is so particularly because a minority institution may wish to emphasize secular education. Minority institution may wish to emphasize secular education. The founders of the minority community may choose to populate the managing boards or a comparable authority responsible for the day-to-day administration of the institution with persons belonging to the same community. However, they are not compelled to do so. They may wish to appoint persons who do not belong to their community but who they deem fit for the proper administration of the institution. If they want to have a particular minority people to administer it, they can do so. Otherwise, they can have an administrator from the other community also. This may be the case for professional colleges which offer specialized courses such as law, medicine or architecture, where the founders may not possess the knowledge, may not have the experience or insight necessary to manage or administer the institution personally. So the test to be adopted by the court, this is para number 139, dear friends. I have read para number 135, 136, 137. From 135 to 137 deals with interpretation of the term establishment, idea, purpose, implementation. 137 and 138 is deals with administrative structure. Now 139 is the test to be adopted by the court is whether the administrative setup of the educational institution affirms the minority character of the institution. If the administrative structure of the educational institution does not reflect its minority character, or when it does not elucidate that the educational institution was established to protect and promote the interest of the minority, it may be reasonably inferred that the purpose was not to establish an education institution for the benefit of the minority community. If the minority institution does not benefit the larger students who belong to that particular community, that means it may lose its character. So therefore, dear friends, we have seen the test, what is the establishment, and how to that administer. The term administer is also interpreted. Now moving on to the conclusion of the judgment. This is at para 116. Dear friends, there are several other issues are also discussed in this case, but I am not touching upon those issues. Is what is important, what is the core subject to test the minority, that alone we have dealt with. Conclusions, para 116. In view of the above discussion, the following are our conclusions. A. The reference in Anjuman-e-Rahmaniya of the correctness of the decision in Aziz Basha was valid. The reference was valid. Because the preliminary objection by the Union of India was 2 judges. How can they question the 5 judges bench? Therefore, addressing referral itself wrong. That objection was overruled. The reference in Anjuman-e-Rahmaniya of the correctness of the decision in Aziz Basha was valid. The reference was valid. The reference was well within the parameters laid down in Central Board of Dawoodi Bohra Community. This is the landmark judgment with respect to the how to make a reference to the larger bench. So it is well within these parameters. B. Article 30 clause 1 can be classified as an anti-discrimination provision and a special right provision. A legislation or an executive action which discriminates against religious or linguistic minorities in establishing or administering educational institutions is the ultra vires Article 30 clause 1. If there is a legislative action or a state executive action, if they are going to affect the rights of the minority institutions, that it would amount to violation of Article 30 clause 1. This is the anti-discrimination reading of the provision. Additionally, a linguistic or religious minority which has established an educational institution receives the guarantee of greater autonomy in administration. Therefore, this is a special right reading of this provision. So therefore, the honorable judges have viewed Article 30 clause 1 in 2 ways. From the one angle, they have seen that it is a non-discrimination clause. The second angle from which they have viewed is, it is a special right providing to the minority institution, because they can have their own affairs, like whatever to be taught, they can do so. C. Religious or linguistic minorities must prove, see, it is a burden on part of the institution. Religious or linguistic minorities must prove that they established the educational institution for the community to be a minority educational institution for the purposes of Article 30 clause 1. They have to fulfill 2 conditions. That is, we have established this minority institution, and this minority institution they will come under the protection of Article 30 Clause 1. D. The right guaranteed by Article 30 Clause 1 is applicable to universities established before the commencement of the Constitution, because the Constitution of India has Article 30 Clause 1 protection is available even to the universities established prior to the adoption of the Constitution. E. The right under Article 30 Clause 1 is guaranteed to minorities as defined upon the commencement of the Constitution. A different right-bearing group cannot be identified for institutions established before the adoption of the Constitution. F. The incorporation of the university would not ipso facto lead to surrendering of the minority character of the institution. The circumstances surrounding the conversion of a teaching college to a teaching university must be viewed to identify if the minority character of the institution was surrendered upon the conversion. The court may, on a holistic reading of the statutory provisions relating to the administrative setup of the educational institution, deduce if the minority character or the purpose of establishment was relinquished upon incorporation. What they are saying is, see, when the college, though it was established in the year 1877 and legal status it was incorporated in the year 1920, when we are converting a college into a university, whether does it lose its minority character? The answer is no, unless and until the benefit goes to the right person. By the very fact that it is incorporated by the statute, does it mean that it will lose its status? Now, G. The following are the factors which must be used to determine if a minority established an education institution. Number 1. The indicia of ideation, idea, purpose and implementation must be satisfied. First, the idea for establishing an educational institution must have stemmed from a person or group belonging to the minority community. So, idea must come from that minority community. Second, the educational institution must be established predominantly for the benefit of the minority community. Third, steps for the implementation of the idea must have been taken by the members of the minority community. 2. The administrative setup of the education institution must elucidate and affirm the minority character of the educational institution and that it was established to protect and promote the interest of the minority community. So, these are the principles laid down by the Honorable Supreme Court in 7 judges bench. What has happened now? The question is whether ALIGARH Muslim University is a minority institution or not. Let us see the answer. Paragraph 161. The view taken in Aziz Basha that an educational institution is not established by a minority if it derives its legal character through a statute is overruled. So, Aziz Basha case is overruled. Why it is overruled? Because in Aziz Basha they have held that this ALIGARH Muslim University is born out of the statute, therefore it is not started by a minority. That is wrong. In this case, already an institution was established. It was continued to be a minority, but it was incorporated. Its existence was recognized by the university. It was existed. I mean, its existence was recognized by the law. But even apart from the law, it was already existing. So, therefore, the law laid down in Aziz Basha case is wrong. Therefore, it is overruled. 7 judges bench overruled Aziz Basha's case. Now, the question of whether ALIGARH Muslim University is a minority education institution must be decided based on the principles laid down in the judgment. So, it is not yet decided, dear friends, whether ALIGARH Muslim University is a minority institution or not. It is not decided in this case. What they are saying is, we have given the principles. Based on these principles, it will be decided. The question of whether ALIGARH Muslim University is a minority educational institution must be decided based on the principles laid down in the judgment. The papers of this batch of cases shall be placed before the regular bench for deciding whether AMU is a minority education institution and for the adjudication of the appeal from the decision of Allahabad High Court in Malay Shukla after receiving instructions from the Chief Justice of India on the administrative side. The reference is disposed of in the above terms. Pending applications, if any, stand disposed of. So this judgment was authored by former Chief Justice of India, Dr. D.Y. Chandrachud, and on behalf of Honorable Justice Sanjeev Khanna, Honorable Justice J.B. Pardiwala, and Honorable Justice Manoj Mishra. So for himself also Lordship has authored. Apart from that, he has authored on behalf of all other 3 judges also. So thank you so much, dear friends. Now the principles are enumerated, but that has to be decided based on the principles. Now with your permission, may I request our guide, philosopher, Mr. S.K. Patri sir, to come and address our audience for few minutes. Yes, please. Just few minutes, dear friends. Then we'll have our group photo. Just hold it. Just hold it.
First, I'm thanking Raja, my dear friend, and all my great friends. Why I came here today? Because it's the reopening week of the bar after the summer vacation. Whenever I come here, I get more exposure because of Raja. And why I'm liking him? Because I have gone to his house also, home in Madurai. We have a lovely fish there. I am not touching anything what I have said because it is such a scholarly lecture. I am not such a scholar like him, but I can give an outward look. He is a nice person. I cannot say more. I've seen his family. I have visited the great city, cultural city. I want to show that he is such a lovable man. He is a lovable family, parents, all the family members so well, and he's teaching so well. So I want to that why you should love him more, so that you will come more. You will tell others that you should come. He's teaching so nicely. He's like a professor teaching. He's like a lawyer is arguing. But I will add something because of his lecture so nice regarding that minority case. I will never touch I have read that judgment, not so minority like him. But what I understood from that judgment, I can say that minority issues, it is always hurting the nation since we got our independence. Before that, it has hurt us and we got partitions. I'm telling you something more, but not so legally, but you will like it because the lawyers are supposed to know everything. Because of that issue, I am not saying anything controversial. We got independence and we had divided nation. We got a nation which are still fighting for reservation issues. Still we are fighting regarding the creamy layers. We are still fighting that minority issue. There are so many minority institutions, including Ramakrishna Mission, so many things. I am not saying anything, any aspersion against anybody. It is a great country of ours. It is like a great flower with all the flowers like roses and all the flowers you can name it, we have all this. So we are diverse of culture. Now we are the lawyers of the apex court. All persons those who are gathering here, they are the cream of bar, I can say, because they are interested to learn. The student in me at the age of 65 is bringing to hear his lecture. And we are, people say we are learning lawyers. I never say we are learning lawyers. We are still learning lawyers. We are still practicing. We are still learning. We are learning from Raja, we are learning from you, learning the newcomers, learning from interns. My role is only to say that the best of the country's future is with the lawyers. And the best of the things are with you people. India is a secular country, it will remain secular, but we'll always do for the humanity. We don't focus on always minority, always focus on the reservation issue. You go beyond that. It's a country of 150 crores of people. If you go to by near population standards, after China, we are number 2. Now we are above China. And so we are the number 1 country. We should show to the world that in secular aspect, in religious aspect, we are really secular. We are doing justice to everybody. In reservation issue, we should think that as per their abilities, as per their qualifications. Let them read anywhere. They like it. There should not be so much reservation. There should not be this issue of minority that he cannot come. It should open to everybody. Merit, it should be the criteria. Whether it is a minority institution, it is any other institution, government institution, let the merit get its place. I am not against anybody. The ability comes. Let your qualification come to picture. Let the morality come to the picture. Let your intellect come to the picture. So that India will be a great nation. We have the most youth population of the world. Most youth population of the world. So we if you have a gold, we have diamond, we say that we are mineral rich. But I say, and you will also say, that India is the greatest country in earth because you have human resources. That is also the youth resources. So that is the only thing to inspire you all. That lawyers of this country should unite and you listen to Raja. Come that you should become a good lawyer. That is the only thing, only to give a boosting thing, because I am a person to touch his argument because he's so nice a person, analytical threadbare. So I am just giving a outer aspect what he has taught to us. He's a nice person. You follow him. He is like your guru. Even if his age is आपसे छोटा भी हो सकता है, but he is like a guru. Respect him and come and always inspire your students and your friends. They should come there so that the group will develop and this show should continue till our lifetime at least. Thank you, sir. All the best. Raja, God bless you.
Thank you, sir. Thank you so much.
Great city.